Sir, one Mr. Manjunath asks, for the purpose of development, government takes property from the people, but there are people who live in forest areas. So when the property is taken by the government, they lose their natural rights also. So how to expand the area of understanding the natural rights that are affected when the property, particularly the land that is acquired by the government for developmental activities?
It is all, I think, both liberty and property are vulnerable to attack. Means danger to property is not from our neighbors or a habitual thief, but it is from ruler. That is why why it is they are declared as natural rights mean they are guaranteed against the government. They are guaranteed against the government. It does not mean that they are absolute rights. Government is what government is theoretically. It is the trustee of the people. Government is trustee of the people. In every governmental action, public interest is involved. The public interest is involved in every governmental activity. Because of these acquisitive activities of the rulers, you are pointing out that is acquisitive activities of the ruler, you are raising this issue. On one hand, customary rights are natural rights of the people. On the other hand, the economic development or something like that. Both are equally important. Both are equally important. Gauging or measuring of their value depending upon the time and place. Depending upon the time and place. Therefore, there may not be a full prohibition nor justification in this matter. Therefore, that even if we refer to charters of 12th century, Henry II, Charter of Henry II in 12th century, the first right guaranteed is customary right against the ruler. Then property right, estates or gifts. Then liberties. Protection of customary rights, protection of liberties, and protection of estate, that is the property. The priority is given to customary right. First one is the customary right. But that was the 12th century understanding of the importance of customary right. But today, that is why the changing situation. Therefore, theories are there, both to support or to both to justify or de-justify. No theory is providing a solution to all our problems. Theories are there to justify the action either way. That is what my view.
Next question is from Mr. Mupur Prasad. He says that intellectualism of a person is developed over a period of time as he grows with the resources of the society. Why intellectual property right is attached only to a particular person when so many people are responsible for his intellectual growth?
No doubt, the individual cannot do anything. That is what repeatedly I covered in my, I think, presentation. Without the participation of others, the public and the stakeholders, individual cannot enjoy the benefit of his intellectual, either invention or creation like that. That is what we already referred to. But the thing is, if you compare, if it is corporeal property like lands or buildings, there is no time limit, no. They are all inheritable rights. Even after the death of the owner, so those rights survive. They are inheritable. But whereas here the time limit is, what is the time limit? I am not familiar with IPR law, but there is a time limit, no, in protecting this intellectual property right. On one hand, there must be a reward to the inventor. There is one theory, ethic and reward theory. That is why everybody, legal expectation, that is the expectation is that one can enjoy the benefits of his own labor, his own acquisitions, or his own inventions. The same principle is followed in case of intellectual property right also. But the time stipulation is there. What is that time stipulation? Is it I think justified how many years the benefits or enjoyments can be to be given to the that is inventor or the author of a book like that. It is debatable. In fact, I don't know is there any other limitation other than the time that is time limit.
So, Professor G.B. Reddy sir can elaborate on that aspect, sir. As to other limitations on intellectual property rights apart from time limit.
Was that?
Yes, sir. Apart from the time limit, what are the other limitations that are there on intellectual property rights?
Yeah. And in fact, sir has already clarified it, but I will once again remind the participants that intellectual property rights, though have the shelf life of a banana, that's what Bill Gates said. Every intellectual property right will have the shelf life of a banana. But there are certain forms of intellectual property rights and certain rights in respect of those intellectual properties which will remain in the public domain, private domain forever. Take, for instance, geographical indications of goods. So you're talking about champagne as a GI, or Scotch whiskey as a GI, or Paris perfume as a GI. Now, almost they are kept in the, private domain for the last about 100 years. Take the case of the moral rights of authors. Copyright expires, lifetime plus 60 years in India or plus 70 years in USA. But moral rights still remain. And they are recognized under the Copyright Act as the special rights or moral rights. This is another important aspect. So we enjoy these rights irrespective of the lapse of the intellectual property rights, which have the limited or stipulated time periods to be kept in the private domain. I think this is known to one and all. Sir also has explained. Second thing is about the joint possession or not possession, but joint ownership of intellectual property rights. Sir has already explained, but some kind of intellectual property rights can't be owned individually. Geographical indications, for instance, they are community rights. It's a group of people who own the geographical indications. It's not a single individual. It is group of about 30 plus weavers from Pochampalli village near Nalgonda who own GI in respect of Pochampalli Ikat. Same is the case with almost every kind of intellectual property. That way, the joint ownership is certainly accepted. So, sir has clarified so many things. In fact, nobody really thought about the jurists or the modern lawgivers like Solomon talking on copyright. And it is a revelation to all of us. Like, because, in our quest to learn something, we confined ourselves mostly to the intellectual property books, sir, whether it is Cornish or, Bainbridge or Narayanan or someone else. But the jurisprudential aspects, I think they need to be understood much better, and they can be understood much better only if we are exposed to, the scholarly expositions like the one made by Professor Y. Pratap Reddy, sir.
We have another question from Mr. Ritvik. He asks that if the metaphysical theory can be explained. He found it difficult to understand the actual meaning. So he is requesting to explain with an example.
What is titled as metaphysical theory in our discussion was the contribution of Hegel and Immanuel Kant. They were also they were also philosophers, undoubtedly. Their approach was philosophical and idealistic and metaphysical. What is metaphysics means? Beyond physics. There is rich literature emanated from Immanuel Kant on it. The approach is freedom of individual. Freedom of individual was the central, I think, freedom, that is the freedom of will or freedom or liberty of an individual. That has been the essence of their approach. Even if we think not metaphysically, even positively, I gave the example of no personality development without property, no liberty. Liberty has no meaning without property. That is what I discussed already. What we can do without property? Property here includes, in wider sense, property includes all these assets, consumables, movables or immovables, whether it's real or personal property, whatever it be. What we can do without property? That is the essence of this private property. That is the individual claim over the property for his development, for his personal development, has been the crux of that theory. It needs no specific, I think, the concrete example. What we do without property is clear. We need shelter, we need food, we need everything, no? Therefore, the essence of property are essential. That is how it is essential. It has been explained from their own angle.
There is another question from Mr. Mohan Rao. Can there be specific theory that speaks out about the origin of intellectual property and its attribution, and whether intangible property rights are equated with intellectual property rights?
All intangible properties are not intellectual properties. Though it is in different, I think, language, it has been discussed earlier. There is material things, immaterial things. Corporeal property, incorporeal property. So therefore, all incorporeal properties are not intellectual properties or intellectual property rights. So there are exclusions. Those exclusions are already listed out and not discussed in detail, like servitudes or securities or leases or mortgages or like that, liens, etc. They are all intangible. They are all rights. They are all incorporeal, but not intellectual. Even commercial goodwill can be distinguished from other intellectual property rights. Commercial goodwill, though it is incorporeal, that is intangible property, but it is not it does not come under the head intellectual property right.
There is next question from Mr. Lavaraju. Sir, possession is 9 out of 10 points of law with reference to IPR. How can this principle be applied to determine the rights of individuals?
Possession, because this concept of possession, especially the physical control, possession is a verifiable fact. Ownership is not. Ownership is a legal relation between individual and a thing. Possession is only an evidence of ownership. That is why 9/10 of ownership. In most of the cases, possessors are the owners. Means 9, according to strict interpretation, 9 out of 10 cases, possessors are the owners. That is why possession is presumed to be evidence of ownership. That is prima facie evidence of ownership. This maxim is developed, in fact, in the context of chattels, movable properties. Not immovable property. Immovable property equally applicable, but it is highly relevant in movable properties. If there is a dispute as to the title over immovable property, possession is the, I think, major evidence. If it is immovable property, along with possession, there can be some other aspects to be proved. Title should also be proved. Mere possession will not confer any ownership. If it is immovable property, there is a real property. Therefore, this maxim is developed long back with respect to the movable properties. Over a period of time, when all these are brought within the grips of law, the evidential, that is, principles are incorporated in procedural law also. In the Indian Evidence Act also, there is a provision on proof of ownership, where possessor is presumed to be owner, till contrary is proved. With respect to intellectual property rights, that is what your possession is only a presumption. Because when it is incorporeal, how to establish the physical control or physical relation between a person and the intellectual property right? When the right itself is incorporeal, it can be presumed, that's all, if it is in use or enjoyment. Use or enjoyment is the basis to decide in whose possession it is.
Next question is from Mr. Chandrasekhar Patnaik. Sir, can we have joint intellectual property rights like in physical properties?
Even if with my limited knowledge, if it is copyright, can't it be a right of two or more? Even if it is patent, so applying the same analogy, even if it is patent, it can be
Yes, sir.
acquired by two or more persons. There is no bar. I think there is no prohibition.
Yes, sir. Thank you so much, sir. Sir, if you permit me, I have a personal question. Like, if you allow me, I would like to ask.
Proceed.
Yes, sir. Thank you, sir. Sir, the debate around the right to private property and intellectual property is also in the nature of private property rather than public property or common property. So this balancing of interests and balancing of rights, that is public rights and private rights. So can you please give your opinion as to what is the way forward, and in your opinion, how should intellectual property be capitalized, and whether the system that we have now can be improved, or is it up to the mark?
Since we are governed by a constitution, there is a change in our the constitutional philosophy as to the public property and private property relation is concerned. 39 clause B, 39 clause C lost their relevance in the past 2 or 3 decades, 2 decades especially. When we are living in this era of privatization, everything is privatized. So everything is privatized. There can be regulatory powers, we know it. You all know the police power or the eminent domain or some other power with the government. There is no absolute right. No right is absolute, subject to so many restrictions. Therefore, depending upon the policy of the changing policy or the political philosophy of the state. But the intellectual property regime or property rights regime is not, I think it is not the problem within the constitutional framework within India. Since we are bound by, that is the difference, no, that is the difference between our other properties and intellectual property rights. Here the right is not only against all others in India, it is a right against the rest of the world, if I am not wrong. Therefore, how the governments or their policies can be different from that of the international regime.
Thank you, sir. Thank you so much for the lecture on the theory of property and IPRs, and also for patiently answering all the queries, sir. Now I request our IPR chair professor at DPIIT IPR-Chair Osmania University, Professor GB Reddy, sir, to please proceed with the session.
Thank you so much, sir. Thank you, Dr. Irfan. Really, it has been a feast to, hear or listen to your lecture, sir. And we are really very happy. I'm very sure that the remaining participants also must have really cherished as well as relished whatever they have learned from the jurisprudential perspective of the property and theories of property. And we wish to have many more, such presentations from you, sir. Thank you so much, sir. I thank our team from Osmania University, IPR-Chair, Dr. Irfan Abbas, Mr. Nagaraju, Mr. Srinivas Rao, Ms. Vaishnavi, and others for making this evening a wonderful one and a fruitful one. Thank you.
Thank you, everyone.
Thank you, sir. Thank you so much, sir.